Hi there, this is Jonathan Ginsberg, and I'd like to talk to you today about a problem that does arise sometimes in bankruptcy cases, and that has to do with recent credit card use. Obviously, people that are struggling will look to use any source of income or any source of money they have, and if they have credit cards with available balances, sometimes it can be very tempting to use those credit cards. The problem is that if you use a credit card when you really have no reasonable expectation of repaying the debt, that can be grounds for a challenge to your bankruptcy case. On the other hand, the Bankruptcy Code to a certain degree realizes and recognizes that people who are desperate and need to have money for food and shelter and clothing and so forth may use their credit cards, and so in some respects the code does give you some leeway with that. What I want to do now is to give you some perspective about when you can use credit cards and where you cross that line, where you get to the point where the use of credit cards is such that you're likely to face a challenge. So obviously the first thing I would tell you is if you can possibly stop using credit cards, you should stop using them. I tell my clients, try to put at least 3 or 4 months between your last use of your credit card and filing bankruptcy, if at all possible, because basically what that means is that you're not showing a pattern of use right up until filing, and the further you go in time between your last use of a credit card and filing bankruptcy, the better. Obviously that's not always possible, but that's the ideal situation. Secondly, if you're going to use a credit card, choose one. Don't try to spread it around them in 4 or 5, because if you're going to have a problem, it's better to have a problem with one than with 4 or 5. And that's, I think that's kind of common sense, but I would say if you're going to choose one with the lowest possible balance, because again, you don't want to have to deal with a credit card company you owe $15,000 to. They're going to have more leverage against you than one you owe $1,500 to. So if you're going to do it, choose one and really just limit it to using it for food and clothing and shelter. Keep your receipts, keep a log of what you're using it for, and avoid using it for things like movie rentals or buying electronics, things like that. So you really want to make an effort to use it just for food, clothing, shelter, just the essentials. The way the law is structured, and basically what I'm talking about is the law that gives Section 523 of the Bankruptcy Code. This gives creditors the right to challenge your bankruptcy. And basically the challenges would be if you've used your credit card within, I think it's 70 days, within a couple of months really, of filing, there is a presumption that is wrongful if it's not for food, clothing, and shelter. But my take on it is any use of credit cards within, I say 3 months is going to be looked at very, very carefully. Certainly within 2 months, you're really, really pressing your luck. So that's what I would say as far as the first step there is to try to really keep it outside that 2 or 3 month period of time. If you have used it, then what happens is the creditor can file an objection to dischargeability of debt and basically try to use the leverage of litigation to force you to agree to repay some of the debt. And again, if you have to get stuck repaying $500 or $600, that's better than paying $2,000 or $5,000 or $10,000. But that's what would happen if there is a pattern of use over the last 6, 8, 10 months. I've seen credit card companies argue that you should not be allowed to discharge your debt, that particular debt, really going back up to a year. I remember I had a case one time where my client used his credit card to pay income tax income tax return debt, income tax liability. And the creditor argued that as of the date he used it to pay the income tax due, that was the date that he knew or should have known he wasn't going to be able to pay it back. And the creditor wanted us to agree that the entire balance incurred after that date, after that payment of the income tax, should be deemed non-dischargeable. We ended up settling it for about half of that, but again, my client was looking at having to possibly reaffirm or continue to pay $10,000. We ended up, I think, $4,500, but that was the leverage they used. So just be aware that any use of your card within 6, 8 months is going to be suspect, but it gets really difficult when you get to month 2 or 3 prior to filing. And I also would tell you, if you're going to use your card in that year, in that 2 or 3, 4 months, however long it is, try to make a couple of payments. Try to make at least a minimum payment, if not more, before you file. And so again, this is something where if you can possibly wait 2 or 3 months. If you come to see me and we see there's some credit card problems, we may want to have you pay for a couple of months, even if it's just a minimal payment, to again show a pattern of good faith that you're trying to make payments, you're trying to pay this debt, and in a lot of cases that will preclude the credit card company from objecting to your case. Now, as I mentioned, the code section is kind of divided into two parts. One part is they look at specific number of days, and after that they look at your ability to repay. And so they're going to look at the pattern of use over, it could be a year, 2 years, and they're going to try to argue, if they can, that you are not really in any position to repay your debt. And obviously they're going to look at, want to know, were you working during that time? Were you, what were you doing? What were you using the credit card for? If they see a trip to Las Vegas, that's a problem. So again, you want to really limit that card use to the essentials, and certainly when we look at this, when I'm meeting with a client, if you have your statements, that can be very helpful for me to look. And again, maybe we decide to wait 3 or 4 months to let maybe the use of the credit cards is a little more questionable, let that kind of cycle out. So if you had bought Christmas presents for somebody, let's say in November and December, and you come to see me in January, I might tell you to wait until March or April and make payments on that balance, from January, February, March, and so forth, to show some good faith. So that's really the threshold. But I would say that any use of the card within 3 months of filing is going to be potentially a problem, and if at all possible, it's best to wait. And beyond that, I would look overall at the pattern of use. Have you used the card for anything other than really bare essentials? And if you have, it may make sense to let that evidence of use kind of cycle out, so you get beyond 6 or 8 months, so it makes you look a little more credible. Because again, if I'm trying to argue to a judge, it's very hard for me to argue that going to Las Vegas was necessary for financial rehabilitation, or that buying something at Best Buy, a TV or a camera, was really necessary. It sounds like more of a want as opposed to a need. And really, when you're dealing with credit card debt, you really want to avoid that. You don't want to have judges think that you're just buying things and then filing bankruptcy on them. And of course, the big point here is that we don't want to have to deal with any kind of litigation, because if you have to litigate, you got to pay me or some attorney to defend what you've done. And again, you're coming out of pocket for something. The best thing is to preclude it, and that is by really showing a paper trail of good faith and really making an effort to show that you're not trying to abuse the process. And of course, you don't want to be abusing the process. That's not what it's there for. So I hope this has been helpful in understanding kind of the lines that are drawn when you're dealing with credit card use, recent credit card use, and filing for bankruptcy.